We are going to be talking today, this evening, for the next hour or so, about the Fifth Amendment. That's where Miranda comes from. Miranda is designed to protect the specific right against compelled self-incrimination. That's the whole point of the Miranda decision. Is the Supreme Court wants to ensure that officers are being mindful that a criminal suspect has a constitutional right to not to be compelled to incriminate himself. Typically, we think of when someone pleads the Fifth or takes the Fifth. We think of that in a trial setting. This is obviously why the defendant doesn't have to testify in his own trial if he chooses not to in a criminal case. And the Supreme Court long ago has said that protection extends to police custodial interrogation. And the Miranda decision is a means of protecting that right against self-incrimination. Hopefully I'll have a little bit of time at the end. We'll see how things go, to maybe talk about the Sixth Amendment right to counsel as well. That's also, it's very closely related to many of these Miranda issues, but it's a separate and distinct constitutional protection. This is your right to a defense attorney. Once you've been formally charged with a crime, you have a constitutional right to have a defense attorney represent you at all of the critical stages of the prosecution, moving forward. There's some similarities to the Miranda protections here, but it's a very different right. The Miranda right, the Fifth Amendment, that's your right to have counsel present during the interrogation. The Sixth Amendment is your right to have trial counsel. So hopefully we'll have a few minutes to talk about some Sixth Amendment issues here at the end of the presentation. If you've got questions, you type them in the chat. I'll do the best that I can with keeping up with questions, and at the end I'll let you, if you have questions you want to ask about, you can either type them in the chat, or I'll open up to open up your mics and you can ask that way. All right. Miranda warnings and waivers. So here I've been teaching Miranda issues probably for 13 or 14 years now, and no matter where I go, the issues are the same. And I can say this confidently. I haven't done any scientific studies to prove this. This is purely anecdotal evidence. But there's no question about it in my mind. We over Mirandize people as a profession. If we were, to poll officers nationwide, there's no question we give out far more Miranda warnings than the law requires. I call this handing out Miranda gift bags. Free complimentary Miranda warnings are being issued on a daily basis. To me, that's a Miranda warning that you haven't earned yet. If anyone has been to any of my live trainings before, you know very well that I'm not a proponent of free Miranda warnings, because of two things. I'll explain my two reasons why I'm not a proponent of them. Now, it's not a legal problem. You're not typically creating any legal issues for your case if you give a Miranda warning where it's not required. But there are just two other considerations I want you to take in mind before you decide to give a potentially free Miranda warning to someone. The first is that it has the potential to inhibit effective investigation. This free warning that you're giving has the potential to inhibit this investigation that you're engaged in. Let's just kind of think about this logically. You're a detective or you're an officer, and you've got someone that you're going to ask questions to. Let's call them your suspect, and it doesn't matter if this is in your interrogation room at your police station, or you are on the side of the road questioning a motorist on a traffic stop. We've got a suspect. We're getting ready to ask questions. Now, you always have effectively the right to remain silent. A person is generally under no legal obligation to answer questions posed by a police officer for the most part. What the Miranda warning is all about is there are certain times when the police must remind you of that right to remain silent. So we have someone we're going to ask questions to, and then we give them, let's call this a true complimentary Miranda warning. They're not in custody. They haven't earned it, but we're going to give them this free Miranda warning. Now, I'm assuming that your whole hope is that when you are getting ready to ask this person questions, your hope is that this person will answer your questions. It is directly counter-purposeful to that goal than to tell that person they don't have to answer your questions. If I want you to answer my questions, I would think as a police officer, the last thing that I would want to do is tell you, by the way, you don't have to answer any of these questions I'm getting ready to ask you. So that's what I mean by it's directly counter-purposeful. Sometimes we have to do with that. So we give a complimentary Miranda warning to someone who hasn't earned it, telling them they have the right to remain silent, and they, as some people will do, they will invoke their rights. Officer, I appreciate you reminding me of that right to remain silent. I'll take you up on that, and also that thing you mentioned about that lawyer. I'd like to go ahead and avail myself of that as well. So if you could get me that lawyer you mentioned, the one that you said you'd pay for, that sounds like a good idea to me. And here's my contention. Here's the inhibiting effect of investigation. It is my contention that some of those people who have just invoked their Miranda rights after having been given a complimentary Miranda warning, some of them would have talked to you, but for this free warning you gave them. It is because you gave them this free warning, they have decided to not answer your questions. Some people would have otherwise been inclined to answer your questions. So you've shut down that one investigative avenue, perhaps unnecessarily, by giving out this free Miranda warning. The other problem that I see with giving out a free Miranda or a complimentary Miranda warning is half of the warning simply isn't true. Yes, you have the right to remain silent pretty much at all times, but you don't have a right to counsel. The part when we tell them you have a right to have a lawyer present before and during any questioning, that simply isn't true. That right, that Fifth Amendment based right to counsel, does not attach to you, to use the legal terminology. It doesn't attach to you until you find yourself being subjected to custodial interrogation. So that part simply isn't true. No, you do not have a right to have a lawyer present with you during this questioning. And we certainly aren't paying for that lawyer either. That's the next thing we tell them. We're not going to pay for a lawyer that you don't have a right to in the first place. So you're being less than truthful with the person when you're giving a complimentary Miranda warning to someone. Now, well, why do we do that? I've found that most officers that I speak with would agree and admit we over Mirandize people. And the reason is simple. I think the reason is quite simple, is that we lack a firm understanding of the basic Miranda rule. Now, we all learn this in the academy. I would be astonished if you could graduate a police academy in any particular state without having passed a test question where you had to correctly state what is the Miranda rule. We all know that custody plus interrogation is what triggers the Miranda requirement. What I want to focus on here for a few moments is helping better to understand what these two terms mean, the two elements of the warning requirement. If we're missing one of them, the warning is not required. So let's define those two terms. I think let's actually start with the second one, interrogation. What does it mean to be interrogated? This one gives us less problems, but it's still one that is worth mentioning. The Supreme Court's definition of interrogation for Miranda purposes comes from Rhode Island versus Innis. Now, Miranda was decided in 1966. It took 14 years for the Supreme Court to take a case to give us the definition of what it means to be interrogated for Miranda purposes. So for a while, courts were kind of struggling with what does it mean to be an interrogation. In Innis, it dealt with Mr. Innis had committed an armed robbery of a taxi cab driver. Within minutes of the robbery, officer had responded to the scene, broadcast a description of the offender, and a patrol officer encountered Mr. Innis walking down the streets a few moments later, detained him. Detectives showed up on scene, and they placed him under arrest for the robbery. In the robbery, he had pointed a shotgun at the taxi cab driver, but Mr. Innis was not carrying the shotgun when he was arrested. The detectives read him his Miranda rights, and he invoked his right to counsel immediately. Says, I don't want to answer questions without a lawyer present. So the detectives instructed the patrol officers to drive Mr. Innis back to the police station so they could process him there. Well, on the way to the police station, there was two officers in the car, patrol officers, and they were having a conversation with each other. Innis is sitting in the back seat, and they're just talking amongst themselves. They said, you know what, we know there's a shotgun out there somewhere. Apparently there was a school across the street from where the robbery occurred, a school for handicapped children, according to the opinion. And the officer said, well, I sure would hate for one of those handicapped kids to stumble upon that shotgun and hurt themselves. Hopefully the detectives can find that gun pretty soon. Well, of course, Mr. Innis hears the conversation and he speaks up and he says, hold on, turn the car around, take me back to where you found me. I'll show you where the gun is. And that's exactly what they did. And he had hidden the gun under a pile of rocks on the side of the road. Well, his lawyer was trying to have that statement that he made about the knowing the location of the shotgun suppressed. He was saying that his client, his Miranda rights were violated. So the Supreme Court took the case to determine whether, well, were the officers engaged in an interrogation when Mr. Ennis responded in the manner that he did. There's no question he was in custody. He was under arrest. The next question was he being interrogated? And the Supreme Court said, well, we need to define what that term is. And here's what the definition of interrogation is for Miranda purposes. It is express questioning or words or action that an officer should know is likely to elicit an incriminating response. Now, these are words written by lawyers for lawyers. I like to, where we can, maybe come up with a layman's definition, so for officers to easily apply in the field. If you think of interrogation for Miranda purposes as simply asking guilt-seeking questions, you would do well to apply that definition. Now, it's not a perfect definition. It doesn't capture all of the fringe elements of the definition that you see on the screen, but as I like to say, it's close enough for government work, calling an interrogation asking guilt-seeking questions. And ultimately, the Supreme Court said this was not an interrogation. In this case, it wasn't an interrogation. It was a conversation between the two officers. They didn't know, they were not trying to appeal to any particular sensibilities that Mr. Ennis had. He voluntarily made the statement. The court said it wasn't the product of direct questioning, obviously, but they also said the officers were not engaged in conduct they should have known was likely to elicit incriminating responses. I think smart people can disagree about the outcome of this case, but what we take away from Ennis is this definition here. Asking guilt-seeking questions is your definition of interrogation. All right, well, what about custody? What does it mean to be in custody? Well, let's take a look at it. Here's one. This is not the definition of custody, but this is a very important principle regarding custody, and is that we need to remember that when we determine if somebody's in custody for Miranda purposes, we use an objective test, not a subjective test. Subjective tests, those are inquiries where we question how a particular person feels about something. So we would ask, does the suspect feel like he is under arrest? Does the suspect feel like he would be free to leave? Does the suspect feel like he's being restrained in an arrest-like manner? All of those things, those subjective questions that go to a particular person, in this case, the suspect's state of mind, the Supreme Court says is irrelevant, okay, for Miranda purposes. What we care about are the facts, the objective circumstances. And that's what an objective test is, a fact-based test. So we need to know what happened. What were the circumstances of the interrogation? How many officers were present? What did the officers say? What did the suspects say? Where did the interrogation occur? What language did we use to get the person to the scene of the interrogation? All of those would be relevant. And then a judge ultimately makes this determination. After hearing all of the facts and circumstances, the judge would then view this interrogation setting through the eyes of a reasonable person. How would a reasonable person perceive this situation? Not how does the suspect perceive it, but a reasonable person in the shoes of the suspect. And of course, we would need to know what it would be. It would benefit us to know, well, what is a reasonable person? The Supreme Court has told us over the years, and lower courts have added to this, but we've learned that a reasonable person, according to the federal courts, is an innocent person who doesn't suffer guilt-induced paranoia every time the police show up. The fact that we use an objective test actually benefits the police and the prosecution more times than not. It benefits us and what we're trying to prove in a given situation. So whether you realize it or not, it's a good thing that we use an objective test. All right. Now, as far as custody goes, I'm gonna just for time purposes, I'm gonna move to this slide right here. I wanted to focus on this one just for a moment. The next slide I give you, we'll have the test for what it means to be in custody. But I think we can get some really valuable information about the custody test from this slide here. Now, this is primarily a Fourth Amendment slide. These are the three categories of seizure for Fourth Amendment purposes. You might use different terminologies depending on where you work. The investigative stop. I'm sorry. Let's start on the left here. The voluntary contact. You might call them consensual encounters. If you're out in Washington, the Seattle Police Department calls these social contacts. I always thought that was kind of an interesting way. It sounds like two people sitting down having tea to me, a social contact. But at the end of the day, it doesn't matter what we call it. What matters is what it is. For Fourth Amendment purposes, it's a non-event. It's just two people having a conversation. One of them happens to be a police officer, the other a private citizen. The Fourth Amendment only concerns itself with searches and seizures. It's not a seizure. It's not a search. So at the moment, it is not concerned with the Fourth Amendment. That's a zero under voluntary contact. What that signifies is the officer needs zero factual justification to initiate the contact. And as you can see, the Miranda rule simply doesn't apply during a voluntary contact because what element is lacking always? Custody. You cannot, by definition, be in custody during a consensual encounter. Those two terms are antithetical to each other. Moving across the spectrum, now we move into the realm of seizures, the investigative stop. You might call them investigative detentions. You might call them Terry stops. But what they are is these brief seizures of a person, brief restraints on liberty, justified by reasonable suspicion. And then the more consequential seizure is the arrest. Now, when it comes to Miranda, we're very good with the arrest. I think officers are very well versed in understanding that if you're under arrest, you are by definition in custody. So we must Mirandize then if we're going to interrogate after they've been arrested. But it's the investigative stop. There's no question about it. This is where we give out more Miranda gift bags than anywhere else is the investigative stop. Miranda usually isn't required for an investigative stop. Now, I forgot we have one more point to make before we get on to the definition of custody. Here's what it isn't. Many officers are taught that if someone is not free to leave, then they are owed a Miranda warning. That's how you determine if somebody's in custody. Well, that simply isn't true because if I go back to the previous slide, this slide disproves that as being the test. Category 2, the investigative stop. The person being detained is not free to leave. That's the test for a seizure of the person. That's the Fourth Amendment test, if someone is free to leave or not. The person being detained is not free to leave on on an investigative stop. Miranda, though, is usually not required because custody requires something more than simply not being free to leave. Custody requires, and I'm actually going to give you two different tests for custody because I've found over the years of instructing this topic that it actually makes more sense and it's easier to apply in the field if we break down our custodial interrogations to two settings. Those that occur in the police station, like our interview rooms and interrogation rooms, I'm going to give you one test for custody for those. We'll do that one second. All other interrogations, I'm going to call them field interrogations, but it's basically an interrogation that doesn't occur at the police station. It's out in the field somewhere. It's on the side of the road on a traffic stop. It's a pedestrian stop. It's at someone's home. We're going to use this test right here. This is the test for determining if someone's in custody when we're outside of the police station. It is the question we want to ask or the test we're going to apply is this person under arrest? That's easy because if they are, we know they're in custody. Or if they're not under arrest, are they being restrained to the degree normally associated with being formally arrested? Again, lawyer terms written by lawyers for lawyers. Can we break this down a little bit or condense this a little bit? Sure. Someone is in custody for Miranda purposes if they're under arrest or that the officers are employing arrest-like measures. Okay. I just saw Rhode Island versus Innis, INNIS, was the name of the case, Amanda, on the chat. Under arrest or employing arrest-like measures is the test. Okay. Now, if you look at this line here, which says, whether there's a formal arrest, obviously that means we place someone in arrest. The part after the or is what I want to focus on. This is your Terry stops. Okay. The Terry stops that involve restraints on freedom of movement to the degree normally associated with arrest. Those are the ones that trigger the Miranda requirement. Like these. Let's look at these three pictures right here. Very quickly, we have a gentleman sitting on a curb in handcuffs, being questioned by an officer. We've got a guy locked in the back of a police car, and then we have a gentleman here surrounded by about a platoon of police officers, or for some of you, your entire police departments. If we were to ask average everyday American citizens, people not police officers, the guy sitting on the curb in handcuffs. So we said average everyday American citizens. Does it look like this person is A, being briefly detained for questioning, or B, getting ready to go to jail? Most, I think, average everyday American citizens who are not law enforcement professionals, who all they know about police work is from what they see on television, they would say A, it looks like that guy's getting, I'm sorry. B, it looks like that guy's getting ready to go to jail. B, it looks like he's getting ready to go to jail. And we would say, well, why would you say that? Because we haven't given you any other information. They'd say, well, every time I watch Law and Order, whenever Elliot and Olivia break the handcuffs out, the guy goes to jail. Okay, so handcuffs equals jail. I think they'd say the same thing about the guy locked in the back of a police car. It looks like the police have more than a couple of questions for him. Looks like he's going to jail. And the same thing with a guy surrounded by a bunch of officers. But if I ask that same question to you all as law enforcement professionals, A, briefly detained for questioning, or B, getting ready to go to jail, you'd sit there silently waiting for choice C, where choice C is we need more information to answer your question. And that would be the correct answer because these could be Terry stops or these could be arrests. We would need more information to answer those questions. But here's the teaching point. Since these are the types of restraints average everyday American citizens would associate with being arrested, these are the things that during a Terry stop, if you use handcuffs on someone, if you lock them in the back of a police car, if you surround them by at least two or more, I'm sorry, at least more than two, so at least three officers in the immediate area being questioning the person. These are arrest-like measures. They don't necessarily have to be under arrest, but these are restraints that people normally associate with being arrested. So a good indicator that your Terry stop has evolved into an arrest-like detention is the use of physical restraints on that person. Now, it's not categorical. We can still interrogate some people without Miranda warnings, even though they're wearing handcuffs or even though they're locked in the back of a police car. But these types of situations typically require some kind of mitigation on our part, like telling the person they're not under arrest, explaining why they're in handcuffs. We've looked at your criminal history. You have an extensive history of assaulting police officers. You're in handcuffs for our safety and more importantly for your safety. Do you understand that? Those kinds of things that if we say can take out some of the arrest-like feel of these handcuffs and locking people in the back of a car, but they are very strong indicators of someone being in custody. But most Terry stops across this country, in most jurisdictions, look more like this: just two people having a conversation. In some jurisdictions, many look more like this, but these in most places, these are not your typical Terry stops. That's why it's fair to say most Terry stops, most investigative stops don't require Miranda because they lack that arrest-like feel to them, such as these right here. Now, the other situation, the interrogation in the police-dominated facility like the police station, here I like to say is where the not free to leave test works beautifully. So Oregon versus Mathiasen is just one case that deals with this issue when we're questioning somebody in a police station. We can still do Miranda-less interrogations in a police station. We do them all the time. We do voluntary contacts all the time. It depends on the language we use to summon the person to the scene, how many officers are present, the physical makeup of the room, all kinds of the things that we would normally consider. But the test simply is, here's where you're not free to leave test works. If we're interrogating somebody in a police-dominated facility, using the not free to leave test is very simple. We don't, we don't typically think of Terry stops as occurring in a police station. Those are more of your field type of encounters. So the test for interrogating somebody in a police station is simply, would a reasonable person feel like they were free to get up and walk out of this room, yes or no? If the answer is no, then they are in custody for Miranda purposes. If the answer is yes, then Miranda certainly would be not required. All right, so those are the definitions of custody and interrogation. Hopefully, with the definition of custody, maybe having a little bit better understanding of it, we can maybe cut down on some of the gift bag giving. I'm not saying we're going to completely eradicate the free Miranda problem in our profession, but I think we can cut down on that with a better understanding of those two elements. Let's just a moment or two about the Miranda case itself. Not everybody is familiar with what exactly happened here, but here he is. There's Ernesto Miranda. He's arrested by the Phoenix Police Department in 1963 for kidnapping and sexual assault. He is interrogated after his arrest, and he eventually confesses to his crime. Now, it turns out his confession is going to be critical to the prosecution of this case because there isn't a lot of physical evidence. And although the victim was able to identify him in a lineup post-arrest, it was a very tenuous identification at best. So not a really reliable identification. The case is going to hinge on the interrogation, and the defense attorney realizes that. So he motions to have the confession suppressed. He is saying that his client's rights were violated because he was not told he had a right to have a lawyer present during his interrogation, which he did have that right, and he wasn't told that. But the trial court judge overruled the motion. He said that the confession was voluntary. Yes, the police did not tell him about having a lawyer present, but it was otherwise a voluntary statement. He was not coerced, threatened, harassed, anything like that. So it was a reliable confession. It's admitted. He's convicted. He appeals his conviction ultimately to the Supreme Court of the United States, and as most of you know, his conviction was overturned. The reason it was overturned was because he was not advised of his right to counsel. So therefore, the confession should have been ruled inadmissible, according to the Supreme Court. So Miranda is entitled to a new trial. Now, the new trial, though, the prosecutor has to either come up with new evidence, or he's going to have to let Miranda go, let him free. Well, unfortunately for Ernesto, but fortunately for the prosecutor, there is new evidence. The new evidence is apparently Miranda's girlfriend, who's not the victim, but she is willing to testify against him in the new trial. Apparently, he has confessed to her that he committed this offense. So she testifies. He is convicted a second time. He's sentenced to 25 years of state prison. He's paroled in 1973. When he gets out of prison, he realizes he's relatively famous. Because when the Miranda case was decided in 1966, it was truly a landmark decision, and it was a very controversial decision. It made all of the news. There was a lot of debate back and forth in public and academic circles about whether the case was rightly decided. If you ask police officers and prosecutors at the time, they would have said no one will ever confess to a crime again because of this new rule. So there was a lot of debate, and it went on for years and years, and it's still to some extent is being debated today, but particularly up through the mid-70s was a hot topic. So Miranda gets out at this time, and he realizes, hey, I'm the guy everybody's talking about with this case. So as any good American would do, he attempts to capitalize on his newfound fame. And how does he do that? He decides he'll sign and sell Miranda rights cards because, after all, he's Miranda. So now I don't know for sure if this is his signature. If it is, I would be the first to commend him on his penmanship because he certainly has done a nice job with that. But that's what he does for a short period of time, signing and selling Miranda rights cards. In case you're interested, how does his story end? Well, his story ends with him getting stabbed. Yep, I see some folks in the comments. He was stabbed to death in, I think, 1976 in a bar in southern Arizona, southern Texas, one of the two. But the gentleman that stabbed him fled immediately to Mexico, and to this day has never been captured. There was another man that was arrested either that day or a couple of days later. He was arrested as an accessory to his homicide. The police went to interrogate him after he was arrested, but before they interrogated him, obviously they had to read him his Miranda rights, and he invoked his rights and refused to speak to the police, and eventually he was acquitted. Hopefully I don't need to explain the irony of that situation to anybody in here, that the only person ever held or tried in the death of Miranda was acquitted in part due to the Miranda warnings and the Miranda rights that were invoked in the investigation of the death of Miranda. And when the coroner searched Miranda's clothing at the coroner's office, he found a whole bunch of these signed cards in his pocket at the coroner's office. If you go to the Phoenix Police Department, from what I understand, they have a little museum downstairs in their headquarters lobby where they have a bunch of Miranda memorabilia. I believe some signed cards as well down there. A good question many officers ask about Miranda rights is, do I have to read the rights the exact same way they are printed in the Miranda case? And the answer is no. The Supreme Court's addressed this in several cases. Although the rights themselves, the four warnings that we have to give them, you got to give. You can't give three of them and not the fourth one. You have to give them all. But the words you choose are not set in stone. So as long as you get the substance of the rights conveyed, no, there isn't a precise wording that you have to use. If you're looking for a case where the Supreme Court said this was like as close as you can get and it be a good warning. It's this Florida versus Powell case. Apparently the trooper, I think it was a Florida Highway Patrol trooper here. His Miranda warning was quite convoluted. He was barely able to get it out there appropriately. So it was about as close as you could be, the court said, and it's still being a valid warning. There we go. No precise language. You just have to make sure you adequately convey the substance of the rights. All right. What else? The waiver, very important part. Okay, so we've read a Miranda warning. Let's say we've read a Miranda warning to someone who's actually in custody. Okay. Now what we're hoping for is that the person waives their rights and agrees to speak with us anyway, because your Miranda rights are your personal rights. You can invoke them and waive them whenever you want to. Now, if there is a waiver, if we're alleging the person has waived their rights and agreed to speak to us, the burden of proof is going to be on us in this case. We have to prove the waiver was valid in court. So we would need to know, well, what constitutes a valid waiver? There's two elements to a valid waiver, and we would need to prove both of these. The first element is that it was given voluntarily. Okay, it was a voluntary. It was and was of the suspect's own free will that he or she agreed to speak to us. There was no coercion, threats, intimidation, harassment, promises, none of those things. It was truly a voluntary relinquishment of those rights. Okay. And the second thing that we must prove is that it was a knowing waiver. We have to prove the person knew what their rights were and that they knew what the consequences of waiving those rights are. And remember, the burden is on us. A very easy way to prove the second element is to just testify that we gave a proper Miranda warning. Okay, so this is why reading a Miranda warning from a pre-printed card is a good idea, because it's easy to reproduce in court if you don't have a video recording or an audio recording of the interrogation. Reading it from a pre-printed card. One, it's easy to reproduce. Two, you're ensuring that you give the warning the exact same way every single time, but it doesn't have to be read. But we show that we gave a proper warning, because what's contained in a proper warning? All of your rights, and also the consequences of waiving those rights, because we tell them if anything you say can be used against you in a criminal case. So there's your consequence. And very important, after we read the rights, we want to make sure we get some kind of affirmative response from the person that they understood their rights. Asking, do you understand your rights as I read them to you? Having them sign a form, getting some kind of affirmative response is going to be critical to proving they understand what their rights are. Now, the last question that is printed on many Miranda rights cards is what's sometimes referred to as the waiver question. Many Miranda rights cards have one more question after, do you understand your rights? And that question is, having these rights in mind, do you wish to speak with me or waive your rights and talk to me? So some variation of that. That's the waiver question. So if we ask that question and the person says, yes, I will agree to speak with you, that's going to be an explicit waiver or an express waiver. Nothing wrong with that. That's a perfectly valid waiver. That's a good way to prove the waiver. They explicitly said, yes, I waive my rights. But the Supreme Court says it doesn't have to be express. It can be an implied waiver, meaning we don't have to ask the waiver question. And if you talk to some really good police interrogators, many of them will tell you that they prefer to go the implicit waiver route as opposed to asking the waiver question. How does that work? Very simple. Read them their rights, ask if they understand their rights, and then just set the rights off to the side and then begin conversation, begin the interrogation process. And then we're allowed to lawfully presume if they begin to answer our questions in response to, if they're willing to, if they answer our questions, we're allowed to presume they are waiving their rights. We just told them they had a right to remain silent, and they have a right to have a lawyer present during this questioning. They said they understood that, and now here we are moments later asking questions, and they're answering those questions. That implied waiver, the Supreme Court says, it's just as good as an express or explicit waiver. So either way, either is acceptable. Yeah, that's what we just said here. We don't have to get it now. An explicit waiver, I would recommend it in a couple of instances. One, if we're trying to get a waiver of the Sixth Amendment right to counsel, that one I'll reserve that for the end of the program. Hopefully, I have time for that. But the other one, where I would personally recommend going the explicit waiver route is if the person we're trying to get a waiver from has previously invoked their rights during this custodial setting. So maybe we read him his rights and he says, "Oh, I don't want to talk to you." Okay, so we stopped questioning, and then a short time later, whether we're still in the same continuous custodial situation, we're now back in front of them. Maybe they've reinitiated contact with us. Maybe we've been able to on our own reinitiate the contact, so we're giving them a fresh Miranda warning. In this case, I would opt for the explicit waiver, just because they previously invoked, and the burden of proof is going to be on us to show that it was a valid waiver. But it's not necessarily required, but I think it would be a good practice in that situation. Let's talk about yes, the invocation has to be unambiguous. Um, and yeah, we're actually going to talk about that in this next section here. I want to talk about the two different rights that are contained in a Miranda warning: the right to remain silent, and the right to counsel. When do those rights attach to you? First thing you need to understand, and we kind of already covered this with the introductory statements that I made about over Mirandizing people. The right to silence, you effectively have that right at all times. Everyone, for the most part, is under no obligation to answer questions by the police. What Miranda is all about is when the police are required to remind you of that right to remain silent. Okay, so you effectively always have that right. It attaches at any time you're being questioned by a police officer. Now, the right to counsel, though, the Fifth Amendment right to counsel, and this is where the distinction between the two different rights of counsel is going to be important, is the attachment phase. When do you begin to have this right? You don't always have a Fifth Amendment right to counsel. That right to counsel attaches to you when you're being subjected to custodial interrogation. Now, the Fifth Amendment itself, if you were to read the text of the Fifth Amendment, the word lawyer, counsel, attorney, it's nowhere to be found in the Fifth Amendment. So where does this Fifth Amendment right to counsel come from? It comes from the protection against self-incrimination. It's a prophylactic protection the Supreme Court has designed to help ensure that the police are not overbearing someone's will when they're in a custodial setting to get them to confess to a crime. So having a lawyer present is a device the Supreme Court has said is constitutionally required to help protect that right. So it is a Fifth Amendment, sometimes referred to as the Miranda-based right to counsel. It attaches to you when you're being subjected to custodial interrogation. The Sixth Amendment right to counsel, I think I have that. Yeah, so here's what I just said, and I apologize. It's sometimes referred to as the Miranda-based right to counsel. It's not, doesn't come from the text of the Fifth Amendment. It's designed to help protect that right against self-incrimination. It's a procedural protection. The Sixth Amendment right to counsel, though, remember, I said earlier, this is your right to have a lawyer represent you, a defense attorney represent you during your prosecution. So the Fifth Amendment, that's your interrogation lawyer. That's the right to have a lawyer present during interrogation. The Sixth Amendment right to counsel, it attaches to you once you have been formally charged with a crime. Once the state has initiated formal proceedings to try you for a criminal offense, at that point you now have what's attached to a Sixth Amendment right to a defense attorney, and you have that right to have that lawyer present with you all of what's called the critical stages of the prosecution. Um, Formally charged with a crime, and it is I think I have it. We'll come back to the specificity of it. It's a charge specific right. I'll come back to that in just a moment. But just for right now, know that it attaches to you once you've been formally charged. Usually that is at your arraignment, or an indictment by a grand jury is a formal charging, and also if a magistrate issues an arrest warrant against you. In most states, that's also considered formal charging. So the formal prosecution process has begun. When a police officer arrests you, makes a warrantless arrest, for example, that's not formal charging. Just because you've been arrested doesn't mean you have a Sixth Amendment right to counsel. You have to have actual criminal proceedings being formally initiated against you. All right. How does one invoke their rights? I saw a couple people commented in the chat about this, and this is correct. You have to invoke your rights, your Miranda rights. It's not presumed you invoke them, and until you waive them, it's the other way. You're presumed I should say that there is no presumption. It's neutral. You have to invoke your rights. You have to tell the police unambiguously and unequivocally. In this case, the Davis case is referring to the lawyer, right? The lawyer part. You have to make it clear by your words that you're telling the officer, I want an attorney, or I'm not answering questions without a lawyer present. Something along, get me my lawyer, something along those terms. And what is interesting about what the Davis case tells us is that the police, we're not required to seek clarification for ambiguous responses. For example, the suspect says, I wonder if I should have a lawyer for this. Do you think I should have a lawyer for this? My cousin told me I should probably get a lawyer for this. Okay, those are ambiguous responses. They're equivocal responses. They're not. Those are not valid invocations of the right to counsel. And the Davis case tells us we don't have to seek clarification. We don't have to ask, are you invoking your right to counsel? We're allowed to literally ignore these ambiguous responses and continue with the interrogation until they make it clear by their words that they want a lawyer. They don't want to proceed without an attorney. And for right to silence, it's the same rule. Burgess versus Thompson talks about that. The invocation of the right to silence has to be unambiguous and unequivocal as well. And again, we don't have to seek clarification. You can, but it's not. It's the burden of the suspect to invoke his rights, not for us to clarify ambiguous statements. When someone invokes their Sixth Amendment right to counsel, that is not necessarily them invoking their Fifth Amendment right to counsel. So this, if someone, they're being arraigned and they request that the judge appoint them a lawyer for that crime, whatever they're being charged with formally, that Sixth Amendment right to counsel, it only applies to that offense. It doesn't apply to any other crime that we want to interrogate them about, as long as that crime is not related to that formally charged matter. We'll talk about, again, the charge-specific nature, hopefully here in a few minutes. But telling a judge you want a lawyer to represent you on the formally charged matter does not automatically also invoke your Fifth Amendment right to counsel. That has to be invoked separately during custodial interrogation. You can't preemptively invoke your Fifth Amendment right to counsel. All right. Let me see. I'm gonna pause here and just kind of go back and take a look at some of the chat questions. We've got someone say, "What if the suspect just replies lawyer?" I think that's pretty. That's ambiguous. It's equivocal. It can mean lots of different things. They have to clearly tell you that they want a lawyer present. And I just mentioning the word lawyer or saying, "Do you think I should have a lawyer?" Or if they're equivocating on their response, that's not going to be an invocation. Several questions about juveniles. So for Fifth Amendment purposes, the rules for juveniles are the same as adults. The only consideration for juveniles that we want to be mindful of is the waiver process. The age of the juvenile being questioned is a very important factor in determining whether their waiver of their rights was knowing and voluntary. Obviously, the younger the person is, the less likely we're going to be able to show that they voluntarily and knowingly waived their rights, absent having a parent present or some kind of guardian to help them, or an attorney to help them through that process. The Supreme Court case that talks about this issue is JDB versus North Carolina. That's the juvenile's initials, JDB versus North Carolina. They said there's no special rules for interrogating juveniles under the Fifth Amendment, but the age is a factor in determining whether the waiver was valid. Now, many states have a statutory law in their criminal procedure statutes or their juvenile law statutes that do create additional protections for juveniles. Some states require at least notification of the parent to the parent that we're interrogating your child in custody. Some states categorically prohibit custodial interrogation of juveniles unless a lawyer or a parent is present. Some states have a lawyer hotline you have to call whenever a juvenile is being interrogated in custody. So the juvenile protections for interrogations do vary considerably from state to state, but those are going to be statutory protections, not federal constitutional protections. Let's see. What if I read his rights and then I said, I just want to get your side of the story. I mean, there's nothing wrong with saying that as long as he hasn't invoked his rights, as long as he hasn't said, I don't want to answer your questions. We can make ambiguous statements. We can make equivocal statements when we're asking our questions. It's just his invocation of his right to remain silent or right to counsel. That's what has to be unambiguous or unequivocal. So let's see. Yes, most people, you do have the right to remain silent, but most people do lack that ability. It's amazing. And most of you probably can attest to this, how many people will still agree to talk to you, even though you've read them their rights. Oh, here's a good question. From Sean asks, what if they don't say anything after you ask if they understand their rights? Well, we have to get some kind of acknowledgement that they understand their rights, but we can also do this. We could do this constructively. If we've been talking to this person for the last hour, maybe out in the field, maybe it was a traffic stop, maybe we were at their house, we've been talking to them using just plain language, plain English, and they've understood everything else that we've said along the way, and then all of a sudden they're under arrest. And we ask, do you understand your rights? And there's just no reply from that person. We don't get that affirmative response. I think we could potentially prove constructively, based upon our previous interactions with this person, that he has a basic understanding of the English language. We've been able to communicate effectively for the last hour or so, or however long we've been talking. Now, all of a sudden, he seems to have a hard time understanding basic English. I think could be we could probably win that argument, but we would want to articulate what exactly we said with our warning. Maybe we want to maybe repeat the warning, but it use different terminology. But if he just says if he just doesn't respond at all, that's not saying we can't. I'm not going to say categorically you can't interrogate him or continue the interrogation. And also, if he says nothing after so let's say we read the waiver, well, let's say we skip the waiver question, and we begin our interrogation. So he says he understands his rights, or maybe he just sits there silently. We begin our interrogation. The Burgess case we mentioned earlier, the Burgess versus Tompkins, also has some pretty interesting language, where the Supreme Court says remaining silent in the face of questioning by the police is not invoking your right to silence. In Burgess, he sat for the most part silently for, I think it was 2 hours, roughly 2 hours, while the police were asking him questions. He'd answer some non-interrogative type questions, but when they started asking him questions about his criminal activity, he'd just sit there silently. Eventually, after a couple of hours of questioning, he started to answer a few of the questions, and he began to incriminate himself. And his lawyer tried to have some of those statements suppressed, saying that my client invoked his right to silence when he sat there silently in the face of questioning for 2 hours. And the Supreme Court said, yeah, that's not quite how that works. You have to invoke the right unambiguously and unequivocally. Sitting there silently is not invoking your right to remain silent. You have to tell the officer that you don't want to answer questions, or that you want to have a lawyer present. So lots of comments about snow. So I think I've caught most of the questions, at least for the last 5 or 10 minutes. But anyway, if you have other questions, go ahead and type them in there, and I'll try and keep up with them as well. All right. We talked about the invocation of the sixth is not an invocation of the fifth as well. And what do we do once they invoke their rights? Very important, obviously. And this will probably, well, I think I might be able to cover one more point after this. But let's talk about this. Here's a before I give you the Mathis case. Here's a common question officers ask. Okay, I have arrested someone for crime A. I read him his rights. He says I don't want to answer questions, or I want a lawyer. All right, but he's also a suspect in crime B. This other crime I'm investigating has nothing to do with A. A and B completely unrelated. He's under arrest for A. I want to ask him questions about B now. He's a suspect. I don't have enough to arrest him on B, but I want to take advantage of the opportunity that I have him in custody to try and ask him some questions. And so can I do that? Can I change the subject and ask him about questions that are unrelated to what he's under arrest for? Well, the answer is going to depend on whether your Miranda rights are charge specific or not. Then the Supreme Court addressed this very issue in this Mathis case that came out a couple of years after Miranda. And the answer is no, they are not charge specific. So therefore, no, you cannot do that. It doesn't matter what the person is under arrest for. All that matters is they're under arrest or they're in custody and they've invoked their rights. All questioning, I think I have it stated here. Yep. All questioning on all matters has to cease immediately. Okay, so there's no, well, he's under arrest for A. We're not going to ask him questions about that. I want to talk about another matter. We're not allowed to do that. What he's telling you is, I'm in custody. I don't want to answer any of your questions while I'm in custody. Or I'm in custody and I want a lawyer present with you, or a lawyer present during my questioning. So we can't change the subject. It doesn't really matter what he's under arrest for. Can the suspect, I'm sorry, can we reinitiate questioning after we've left him alone for a certain period of time? So let's say he's invoked his right to silence. So we stop questioning on all matters immediately. Is there some point where we can go back to him during the same continuous custodial situation and try again? Well, if he's invoked only his right to silence, the answer is yes. Michigan versus Mosley tells us we get at least one additional bite at the apple. If he invokes his right to silence, we leave him alone for a short period of time, and then we reapproach him, give him a fresh Miranda warning, and then if he agrees to talk to us at the second interrogation, the court has said that that's going to be lawful as long as we have, quote, scrupulously honored the right to silence. What does scrupulously honor right to silence mean? Well, in Mosley, they left him alone for about 2.5 hours, if I'm not mistaken. It's a cooling off period, is exactly what it is. And during that period, we're not badgering him, we're not threatening him, we're not depriving him of food and water and use of the bathroom or phone calls. We just go about our normal booking process. And then we go back to them later with a fresh Miranda warning and just see if he's changed his mind. The Supreme Court said in the Mosley case that 2.5 hour or so cooling off period was sufficient. That was good enough. And he made incriminating statements the second time he agreed to talk to the officer, and the court said that was admissible. That second, that the statement that he made during the second interrogation. And we initiated it. He can initiate it at any time. The suspect can initiate it at any time. It's when the police can reinitiate. It's going to be dependent on which right was invoked. Okay, so right to silence, we get the scrupulously honor, leave him alone short period of time, then try again. What if instead he's invoked his right to counsel? He says, I want a lawyer. Well, here we have what's called the Edwards rule. And the Edwards rule is quite harsh. There's, for the police, it is no more police initiated interrogation period. There is no cooling off period when it comes to the right to counsel. He is not subjected to any further police custodial interrogation until his lawyer is present for that interrogation, or he can initiate it himself. The suspect can always waive his rights and change his mind and speak to us. But we don't get to go back to him after 2 hours and say, hey, can we have you changed your mind about a lawyer, and give him a fresh warning. It just doesn't work that way. It's called the Edwards rule. The Edwards rule is why many detectives will tell patrol officers that when you arrest someone, patrol officer, if you don't have questions for that person, then do not read them a Miranda warning. Because if they invoke their right to counsel to you, the arresting officer, you've prevented me, the detective, from asking questions later on. Maybe when you bring him down to the jail, I want to come down and meet you down there and ask him questions about my case. It doesn't matter what he's under arrest for. Remember, Mathis tells us that. Once he's invoked his right to counsel, no one can interrogate him while he stays in that same continuous custody unless he initiates or unless his lawyer is present for that. All right. Let's see. We are running up on an hour. I didn't quite get to cover everything else that I wanted to.